Hey, thanks for joining our webinar on workers' compensation claims here in Georgia. I'm Gary Martin Hayes. I've designed the material to give you an overview of what happens if you or a family member have been injured on the job here in Georgia. And I know you have a lot of worries. Clients call us all the time asking, who pays for my lost time from work? I'm getting checks, but I don't know if it is the right amount. Who will pay for my medical bills? Do I have to treat with a company doctor? Can I get a second opinion from a doctor that I know and trust? You have the questions. We have the answers for you in this webinar. But before I start, let me also share something with you about Georgia's workers' compensation system. And honestly, this is something I hate to talk about, but it's something that you should know. The benefits that an injured worker receives here in Georgia are pathetically low. But this isn't what they portray on TV, nowhere near. Most people wrongly assume that people are getting rich off of our workers' compensation system. And you've seen the exposés, the gotcha videos. The supposedly injured worker is collecting workers' compensation benefits, claiming they can't work, yet a film crew catches that same worker climbing ladders, roofing houses without any physical problems whatsoever. Folks, this is not the norm. This is not an accurate portrayal of the real injured worker here in Georgia. These people that are milking the system are less than 0.001% of the claims here in Georgia, yet their actions affect those that are really hurt. I wish the TV stations would show what happens to the workers that are really legitimately injured, to the 99.99% of the claimants out there that are struggling to make ends meet because of the low benefits. Well, it's my goal to change the perception that everyone has, that everyone that's hurdling job is just trying to get rich off the system, because nothing could be further than the truth. All right, let's get into this. Since the benefits in Georgia are so low, I encourage you to hire a lawyer to work for you to help maximize your recovery. You got one shot to get your health back. You have one shot to secure all the benefits you're entitled by law to receive. So don't gamble your health, your future, your family's well-being by trying to take on the insurance company and their lawyers by yourself. And make sure you hire an attorney that is an expert in the workers' comp system. All right, let's get into the webinar. In this video, I'm going to explain your rights and the insurance company's responsibilities, and I'm going to cover the following. What are the 3 benefits that you can receive under Georgia law? And I'll answer these questions. Can I sue my employer? Do I ever get to tell a jury what happened to me in the accident? How can I see a doctor that I like versus the company doctor? And finally, I'll address the question that I've been asked the most in my over 30 years of experience handling these cases. What is my workers' compensation claim worth? All right. Let's get started. We're going to begin with this question. What are the 3 types of benefits you can receive under Georgia law? Well, under Georgia's workers' compensation system, an injured worker can receive 3 different types of benefits. Wage benefits, these are often called indemnity benefits, medical benefits, and permanent partial disability benefits, or PPD benefits. And let me start off by covering wage benefits. If your authorized treating physician has you disabled from work for more than 7 days and the employer doesn't have work within your work restrictions, then you are eligible to receive weekly disability checks. So how does the insurance company calculate the amount of the weekly check? Well, they must add what you made in the 13 weeks before your accident. The total amount is then divided by 13. This figure is your average weekly wage. Under Georgia law, the insurance company is required to pay you 2/3 of your average weekly wage. Now, these weekly checks are called total disability benefits, or TTD benefits. You'll receive the weekly check for total disability as long as your authorized doctor has you out or disabled for your work-related injuries. Now, there is a cap on the amount of weekly wage checks, and it depends on when your date of injury happened. All right, and let me say one other thing regarding wage benefits under Georgia law. One of the first things we do for our clients is to get a copy of your pay records. We want to make sure the insurance company is sending you the correct amount of your weekly workers' compensation wage benefits. Oftentimes, the insurance company is not paying you the right amount in your weekly checks. Don't be taken advantage of with your claim. Make them pay everything you are entitled to receive. Now, let's talk about the second category of benefits. That is the medical treatment you are eligible to receive. The employer and workers' compensation insurer are obligated to provide medical treatment to you for your on-the-job injuries. The law requires them to pay for medical treatment that is, quote, reasonably calculated to effect a cure or provide relief to you for your injuries, as long as the treatment is recommended by your authorized treating physician. Well, who is your authorized treating physician? This is the doctor that is in control of the medical issues regarding your claim. Your employer is obligated to post a pink panel of doctors from which you're free to select a physician of your choice. This doctor becomes your authorized treating physician. But let me tell you something that is extremely important regarding the panel of physicians. Most employers don't even have a panel of physicians. If they do, most do not post it. Oftentimes, if they do post it, the panel is not in compliance with Georgia law. According to the rules of the State Board of Workers' Compensation, the employer must have a pink panel posted with 6 physicians listed on it. All right, and this is important. One of the 6 must be an orthopedic surgeon and 1 must be a minority physician. Plus, the panel can't have more than 2 industrial clinics. This is important. If the employer does not have a panel posted, or if the panel is posted but it's not in compliance with Georgia law, you are free to select the doctor of your choice to provide treatment to you. Now, what can you do if you want to find out if your employer has a panel posted or if it's proper? Get a copy of that panel immediately. Take a picture of it, give us a call. When posted, the employers normally hang it by your time clock in the break room, somewhere in the wall in the break room. Again, take a picture of it if you can. Pull out your cell phone, snap a picture. If you don't see anything posted, take pictures of these areas so we can prove it was never posted. I cannot stress this to you enough. If it exists, get it, hold on to it, and let us see it so we can discuss your claim. You may be able to treat with a doctor of your choice instead of the company doctor. Now, the third and final benefit you may be eligible to receive is called a permanent partial disability benefit, or a PPD rating. All right, what is a PPD rating? When you have reached the point where the doctor has done all that he or she can do for you, you are at what most people call in the medical profession maximum medical improvement, or MMI. When this happens, your authorized doctor will be asked to perform an evaluation based on the American Medical Association guidelines to determine what percentage of permanent disability you have as a result of your accident. For example, assume you injure your back on the job. Before the accident, you were at 100%. You were able to bend, stoop, lift, and rotate without any problems whatsoever. But since the accident, even though the doctor has done all he can do to help you, you are not back to where you were before you got hurt. Chances are you never will be. You have difficulty bending, stooping, lifting, and rotating. Now, the doctor thinks you're only 90% of what you were before the accident. Therefore, under the AMA guidelines, you have a 10% permanent partial disability rating. And based on this rating, the insurance company owes you an additional sum of money. Now, once the rating has been assigned, we can use this to evaluate your claim for possible settlement. You got to hear this part, though. Outside of these 3 wage benefits, wages, medical, and that disability rating, the PPD rating, there are no other items for which you can recover under Georgia's workers' compensation system. You can't ask for money for pain and suffering, emotional suffering, or seek the difference in wages you are losing because of your injury. You're limited by law to these 3 benefits, and that is it. And this is all the more reason for you to hire an attorney that specializes in workers' compensation law to make sure you receive all the benefits you are allowed to receive by law. And I can assure you, the insurance company is not in the business of knocking on your door and saying, hey, Mr. and Miss Injured Worker, here are some additional benefits we owe you, or we just wanted to make sure you knew you could receive this or that, and here's some extra money we have to pay you. This is not going to happen. Now, this brings up 2 additional questions we're often asked. 1, can you sue your employer? And 2, will you get your case in front of a jury to tell them everything that you've been through? I understand the reasons behind these questions, especially if you feel like your accident could have been prevented if your employer provided a safe working environment or provided you with better tools or equipment. Sometimes injuries could have been prevented if the employer was proactive in maintaining their machinery and/or equipment. But here's a simple general answer. No direct civil action can be filed against your employer. And here's the reason why. Georgia has adopted what's called the exclusive remedy doctrine, and here it is. This rule prohibits an injured worker from filing a negligence lawsuit against the employer seeking money damages. Under the law, the sole exclusive remedy for an injured worker is to file a claim for insurance benefits under the workers' compensation system. So what is the exclusive remedy doctrine? Well, this rule protects employers from civil actions or any claims by employees that were injured on the job while working for the employer. In exchange for this lawsuit protection, the employer is legally obligated to provide specific workers' compensation benefits to the injured worker. All right. Why do we have the exclusive remedy doctrine here in Georgia? Well, the purpose is to protect employers in Georgia from exposure for two separate actions against them. One for the workers' compensation claim and the other being the civil lawsuit. If the rule was not in effect, it would be difficult for businesses to remain in Georgia with that potential financial exposure. This could result in less commerce, less jobs being available in the state. All right. What other claims may be allowed under Georgia law if you're hurt on the job against someone else? Well, the employer is insulated from a lawsuit, and they can invoke the exclusive remedy doctrine to get protection under the Workers' Compensation Act. But a negligent third party does not have this shield to prevent claims. The exclusive remedy provision does not eliminate an injured worker from being able to sue a negligent third party that was responsible for your injuries. For example, you work as a delivery driver for your company. While you're out doing one of your deliveries in the course and scope of your employment, you're injured in a car wreck. As you go through an intersection with a green light, another driver blasts through the red traffic light that governs his direction of travel, and he plows into your car and causes you significant injuries. And he's cited for causing this wreck. In this example, you can pursue a claim for workers' compensation benefits against your employer, but you can also file a claim against the at-fault driver and his insurance company for your personal injuries, for your medical bills, for your lost wages, for your pain and suffering. This claim against the third party is not barred, it is not prohibited under Georgia's Workers' Compensation Act. Now, please note, you cannot sue your employer for injuries and losses sustained in the wreck. As we discussed, the sole exclusive remedy against your employer is filing for the workers' compensation benefits. Let me give you another example of when you can pursue a third-party claim. Say you're out working using a large chipper. It's designed to take tree limbs and brushes into its opening, and the chips are cut into smaller pieces and it's spit out at the other end of the machine. Your employer is a tree service, but there's a problem with the machine that you're using. Due to its improper design or because of a defect during its manufacturing process, the safety switch or the emergency cutoff system doesn't work. As a result, your shirt sleeve gets caught, it pulls your arm into the shredder. The result, you lose your arm in this horrific accident. You're not allowed to file a claim for workers' compensation benefits against your employer, but you may be able to pursue a claim against the machine's manufacturer due to the design of the machine or perhaps a manufacturing defect. Bottom line, even though the exclusive remedy doctrine is the general rule that prohibits these civil lawsuits against your employer, there are exceptions. So I highly recommend you call us to see if this applies to your specific claim. And please do not delay because evidence can be lost. Now, can you get your workers' compensation case in front of a jury? The answer is no. The workers' compensation system does not use juries, but if your case goes to a hearing, it is in front of an administrative law judge. Now, here's another question. How can I be examined by a doctor that I know, a doctor that I trust, instead of just seeing the company doctor? Well, this is known as an independent medical exam or an IME. Did you know that if you are receiving or if you have received workers' compensation wage benefits in the last 120 days, you may be entitled to a one-time exam with a doctor of your choice. You may be able to see a doctor that you want to go see instead of the company doctor, and the insurance company has to pay for it. Wouldn't it be nice to get a medical opinion from someone other than the company doctor? Now, as with any law, there are certain hoops you have to jump through to request this free exam. And if you don't comply with the law, if you don't jump through these hoops requesting the evaluation, you better believe the insurance company is going to deny your right for this exam. And you may end up being the one having to pay for it. So please don't call the insurance adjuster and try to get your IME without the assistance of an attorney. All right. I'm going to address the question that I've been asked the most over my 30 years of experience handling workers' compensation cases. And here's the question. What is my workers' compensation claim worth? Well, the only honest answer that I or any attorney can give you is this. It depends. There are so many factors that can affect the value of your case. So let me stress this to you. There is no way anyone can give you a full, fair, or honest assessment of your claim without knowing all of the facts of your case. And let me give you just a sampling of some of the questions that we need answered before we can do that fair evaluation. Start with your weekly workers' compensation wage checks. Are you receiving them? If so, how much are the checks? How long have you been receiving them? Is the insurance company paying you the right amount? Here's some other factors. Who is your authorized treating physician? Can you change treating physicians? Was the panel of physicians even posted by law? Or if it was posted, was it valid? What injuries have you sustained? Are your injuries permanent? And here are some more issues that we must address. What additional treatment is going to be necessary? How much will this treatment cost? What if you can't return to the same type of work or job that you were performing before your accident? What if you're not able to return to work at all? Will job retraining be necessary? Are you eligible to receive Social Security disability benefits? These are just a few of the questions we must have answered before we can arrive at a fair value. And this brings me to my final point. Chances are the fact that you are watching this video means something bad has happened to you or to a family member or to a friend, and you're looking for answers. You deserve answers. And if that's the case, then I am very sorry that you or that friend or the family member are going through these difficult times. Should you hire me? Should you hire my firm? We will do all we can to protect you, to answer your questions. We're going to educate you about the process. We're going to alleviate your worries and concerns, and I promise you, we're going to fight to get you all the cash and benefits that you are entitled to receive under the law. Now, the information that I've given you in this webinar, it may or may not apply to your specific case. Nothing is going to replace a consultation with an experienced attorney to discuss the specific facts about your particular claim. Now, why should you contact me about your case? Well, I've devoted my entire career to the handling of workers' compensation, personal injury, and wrongful death claims. I teach other lawyers how we handle our cases. I was selected one of the top workers' compensation lawyers in Georgia by other lawyers. And I even wrote the #1 best-selling book, The Authority on Workers' Compensation Claims in Georgia. In fact, when I started practicing law over 30 years ago, I worked for a law firm that represented insurance companies on the other side of these cases. I know how these claims are handled. I know how to work to maximize your physical and then your financial recovery. And I'm happy to give you a free consultation regarding your claim. All you got to do is pick up the phone and call me. 770-934-8000. You have absolutely nothing to lose by calling me, but think of all you can lose if you don't. I look forward to hearing from you.